In this training module, I'm going to show you how to use our outline to determine if your idea meets the 6 criteria to be patentable. This includes exploring whether an invention is considered patent-eligible subject matter, provides utility, is novel, is non-obvious, has been reduced to practice, and is described in a submission that meets all the formal requirements. By the end of this video, you should be able to evaluate your own innovations to determine if they are patentable. Let's get started. On the screen, you've got a copy of our outline. It's entitled, "Is My Idea Patentable?" If you follow this outline from the top to the bottom, you'll find that you can run through the 6 criteria that I just mentioned, one by one, and determine if you meet all the required criteria. The requirement for patent-eligible subject matter is defined by statute. There are different types of categories of subject matter that are, by statute or by law, considered to be patentable subject matter or patent-eligible subject matter. These include processes, manufactured devices and systems, and compositions of matter. Those aren't the exact words that the laws use, but that's how you can understand each of them. Processes refer to methods or processes, which are a sequence of steps that you go through to perform some technical function. Manufactured devices and systems are things. They're physical hardware or physical things that are produced or manufactured or exist in the world. That's where the word systems would typically be used as opposed to a process. Compositions of matter include different types of chemical compositions or materials that are put together to form a particular substance or composition. Patent-eligible subject matter has been under quite a bit of scrutiny lately in the courts and at the Patent Office. We'll walk through some of the reasons why. For processes, the first step is to determine whether or not your process or method includes some type of abstract idea or law of nature. Laws of nature are things like the law of gravity or other laws of physics. Abstract ideas are simply ideas that somebody has, like an idea for a new business or an idea for solving a problem without actually providing the implementation to solve that problem. Some people tell me about the ideas they have. They've realized a problem, and then they say, I think we should invent something to solve that problem. Well, that's an idea to solve a problem. That's not the actual solution to solve the problem. So abstract ideas and laws of nature by themselves are not patentable. However, pretty much every invention relies on some type of abstract idea in the beginning or some type of law of nature at some point. So, even though they are not patentable by themselves, the courts have come up with a test that says if the process or method based on abstract ideas and laws of nature includes significantly more than abstract ideas and laws of nature, then it can be patentable. In practice, what that means is you need to have something that's tied into technology, often tied into physical hardware or some transformational event where you transform a thing, a physical thing, or perhaps in some circumstances, transform data or the way that data is used. Manufactured devices and systems really don't have much controversy. If you're making a thing, a piece of hardware, a piece of clothing, something that has a physical substance to it, then it most likely will pass the patent-eligible subject matter criteria without much trouble. Compositions of matter refer to chemical compositions mostly, and materials that are combined together to form new materials. These often rely on natural phenomena, naturally occurring things. If something occurs naturally in nature by itself, it is not patentable. However, since most compositions are built on natural phenomena or natural occurring processes, natural occurring chemicals, once those chemicals are modified in some fashion, even synthesized by synthetic means, that modification or synthesis can become patent-eligible subject matter. The second criteria, shown in the middle here, is utility. This is also governed by statutes. Utility refers to whether or not an idea is useful. So ideas are by default considered useful unless they fall into limited category of things that are by default considered not useful. So ideas that defy the laws of physics, things that rely on time travel or perpetual motion, things like that that cannot be verified and appear to, and probably do, defy the laws of physics, are by definition considered to not be useful because they're not actually possible. Everything else in the world is considered to have some form of utility, some form of useful function for humanity, and will pass the utility test without much problem. The next requirement is novelty. This is also a statutory requirement governed by what's called Section 102. Novelty refers to whether or not an idea is exactly the same as a prior known idea, something that's already known to the public, something that's being sold, something that's been published, something that's been described in another area. If your idea is already known to the public in some form or fashion in exactly the same way, your idea will not be considered novel. So it'll be kicked out and will not meet this criteria and will not be patentable. Now notice inside the box here that some of the forms of prior publications or prior knowledge can come from the inventors themselves. It can be made public by you. I was talking with an inventor today who has a formulation for a device, and their formulation is new as of recently. However, they've been making other versions of that formulation for several years. Any of the formulations that they've been making and selling for the last several years, with the exception of the new one, will not be considered novel because they themselves have put it out there on the market and made it publicly known what they're making. This brings up the exception here. If you made it public, but it's been less than a year in the United States, then you can still meet the criteria for novelty. And to make things a little bit more complicated, there's an exception for the exception. If you made it public and it's been more than a year, but that use that was public by you is considered experimental use, then you can come back in to the process and be considered patentable. In order to determine whether or not something is experimental use, there's a set of criteria that can be reviewed. In practice, the experimental use criteria really determine whether or not the way that you used your invention publicly was as a means to actually implement and perfect your invention, rather than to test the marketability of your invention. The next step in the process is to determine whether or not your idea is non-obvious. And this sounds backwards, but it's the way that we look at it. An idea that is obvious is something that would not be patentable. So in order to be patentable, your idea needs to be non-obvious. And this is where a lot of inventors might ask themselves, what's the percentage of difference that I need to have between my invention and other ideas that are already out there in the public? There's not such a criteria for a percentage. Rather, there's a set of criteria that the Patent Office uses to roughly estimate whether or not something is obvious. Now, this is where the examination process with the Patent Office can be very sticky, because you have patent examiners who take some liberties in determining what is non-obvious and what is obvious. And you have patent attorneys or inventors who are then communicating back and forth, trying to convince an examiner whether or not something is obvious or non-obvious. The best way to convince an examiner that something is non-obvious and therefore patentable is to show that there is an unforeseen combination of component parts, some combination of parts and pieces that nobody else has put together. Often that will be the first argument made in the examination process to show that your invention is non-obvious. However, patent examiners will likely come back and say that even though nothing describes your component parts together in the same combination, those parts and pieces can be found in other disclosures, other references, and obviously could be combined together for the same result. The best way to show that your combination is new is to also explain to the patent examiner that your combination has some unforeseen benefits or advantages. Putting parts and pieces together might be expected to end up in a particular result, but if you can show additional advantages to that combination, you'll have a better time showing that your idea is non-obvious over prior art. The fifth criteria to show that your idea is patentable is to show that you've reduced to practice your invention. And you can do that in one of two different ways. You don't actually have to make your invention, although if you do make a version of it, and you have an actual working embodiment, that's called actual reduction to practice. And that satisfies this criteria. Alternatively, if you haven't actually made a working prototype or a working embodiment of your invention, you can constructively reduce your invention to practice by describing it and filing it in a patent application. That filing is considered to be constructively reduced to practice. So by the time you file your patent application, you will have at least constructively reduced your invention to practice and satisfied that criteria. The last criteria for patentability is that you need to meet the formal requirements for your patent application. And those differ depending on whether you're filing a provisional patent application or a non-provisional patent application. In either case, there's a set of formal requirements established by the Patent Office that you need to meet, such as filing fees, timelines, and in some cases, the content of the application itself. So there you have it. If you meet all of these 6 criteria, including patent eligibility, utility, novelty, non-obviousness, reduction to practice, and the formal requirements, then you'll have an idea that is patentable. That's it. You should now be able to evaluate for yourself whether your innovations meet the 6 criteria for patentability.